Hello and welcome to our Spotlight videos where we discuss cutting-edge employment law issues. I'm Tom Spiggle, founder of the Spiggle Law Firm. We help people who've been fired or afraid that they might be, and I am thrilled today to be joined by an attorney in my office, Ivey Best, and we're going to be talking about what today, Ivey?
About mediation.
Mediation. Okay, great. Important topic, very meaty topic. We'll do high level since we're just doing 5 minutes here, but what do you want folks to know about mediation?
What I'm always telling folks about mediation is this is not like court where we need to prove your case or we're going to have someone like a judge agreeing with you or disagreeing with you. That is not the role of the mediator. The mediator's role is to hear and evaluate both sides and be an objective third party. And their role is to, if you're the one asking for money, get you to ask for less. And if you're the one writing the check, try to get you to write more. Right, and get the two parties to meet in the middle. Often when we're prepping for mediation, my clients get really worked up about, establishing their case to the mediator, getting the mediator to buy in on their case, and that's not necessarily the goal.
Yeah, no, absolutely. And, a lot of cases, mediation is the ball game, right? That's where the case is resolved. I mean, and we hope for that, right? That's what we get out of mediation. But you're absolutely right. It is not the place where you're going to establish the facts of your case. I mean, you may certainly get into the details of your case, and a good mediator is going to dig into it. But you're right. Then there's kind of this shuttle diplomacy back and forth, where the mediator is basically trying to get an agreement that every side is slightly unhappy with, which is usually a good mediation. If everybody walks out slightly unhappy, but I think, and you probably do this when you're prepping your clients and see this, that's why it's so important to go in with a game plan, right? Because if you go in thinking, okay, I might get $1 million. I mean, if that's part of your game plan, it's a realistic one, well, then good for you. But you got to go in with, okay, if I walk out of here with this number, this range, I would be satisfied. That would be a good result for me. And it's often, you need to talk to your attorney about that.
Right. Yeah, and a lot of times I hear people, they're asking me for that. Sometimes they want to know from the very first day, what can I get for this case? Like, give me a dollar number, or what should my bottom line be? Or I want my bottom line to be X. And I normally try to offer them a reframe that is, let's see what we can get them to. Let's see what their max number is. Let's see how much money we can get them to put on the table. I want you to get absolutely every penny that you possibly can. I cannot always predict what that will be. So I try to take the mindset going into a mediation. Let's see what their absolute best number is. And then you can make an educated choice, take it or walk away. When you go in with a really firm bottom line, that may not be a range that they're willing to get in, and I would never want a client to walk away from a good offer because they were just so set on that bottom number. So that's the way I try to get people to think about mediation going in. Yeah,
and I think the other point for folks to think about is, because everybody, of course, focuses on the money, which is, of course, a key and important part. But then there are, and usually, right, particularly if you have a long mediation, it can go sometimes all day. Everybody's tired, everybody's a little cranky, everybody's a little hungry, and so you agree on a number. And then the settlement agreement comes through, and it's got a bunch of bells and whistles that you as the client, as the employee, are not prepared for. Whether it's a non-compete, non-disparagement clause, a non-rehire, like all the things that can be fairly standard in severance. So I think it's important, I know you do this, but when you're talking with your attorney, like don't forget those pieces, because it's really difficult when everybody's agreed to a number and then, you get a settlement agreement back and the client's like, I don't want to sign that. Like, I didn't know that was going to be in there, and then it can blow the whole thing up. So if you go in there prepared for that, and particularly where the mediator's there, particularly if it's a judge, like get those pieces, at least in broad aspects, outlined like, hey, I'll sign a non-disparagement, but it needs to be mutual. So both sides, whatever it may be, that's also very helpful, I find.
No, I think that's right. And another thing that I often hear from folks around like a mediation topic is, they want some type of admission, right? They want some language in an agreement, or they don't want to see language that says the employer is not liable. And I just tell them, frankly, most of the time that language is going to be non-negotiable.
Yeah.
Don't let it get you upset. You're still getting a great result. this settlement that you're happy with. So I just tell people, don't let that bother you. That's just standard language that we put in the agreement. The employer is going to require that. And I think once folks get that understanding, they're able to move past that hang up.
Yeah, and I don't know if you've worked with Phyllis Ramsey, who we've worked with in our firm, and I got this trick from her, which I love, because a lot of times, you as the client or the employee, you'll get an offer. Of course, you're not happy with it. You want more, and you want, all these things, which are perfectly reasonable and understandable. But what she had people do, and I stole this tip from her, is before you walk away from a number, write down all the bills that you could pay with. Pay with that. Like I said, really make it tangible for yourself. And if you still want to walk away, absolutely. But like before you shut the door on a number that's not bad, but you're not entirely satisfied with, really think about, well, what could I do with this amount of money? Like what could I buy? What bills could I pay? And sometimes it makes it more tangible for folks.
Yeah, I think sometimes people are so reared up, they're upset, they're hurt. I think rightfully so. They want to go to court, they want to get to that jury, and they're envisioning themselves in front of the jury in their mind. And then to think about being done is maybe, it causes a lot of emotions. And I'll normally ask, think about how good it would lay your head down on the pillow tonight and not have to worry about this anymore.
Yes.
Right? Think about how good you would feel not carrying this burden anymore.
Yeah.
Right? Does that entice you to think about this number more seriously?
Yeah, and especially considering, when we've seen this happen, right? You can go forward and get zero, right? So that really, when you put it in that perspective too, here are the bills you can pay, here's the stress that you're going to relieve, and there's a possibility you could go forward with this and get nothing. That kind of puts in perspective. And of course, we're not strong arming people in settlement. Sometimes it's a right call to walk away from a really lowball number. But those are, I think, three things that can really help, help make what may seem an unpalatable offer and at least in a different light.
Right. No, I think that's right.
Yeah. Anything? Any last words of wisdom before we call today on this piece?
I don't think so.
Okay. It's been very helpful. I appreciate your time today, Ivy, and I'll let you get back to the next thing on your desk there.
Thanks, Tom. Bye.
Okay. Bye-bye.